Hi, I'm Fiona Henderson. Today I'm back on Sydney Harbour on a glorious spring day. I'm outside Luna Park. This week I've been preparing affidavits of lay witnesses in Supreme Court Equity Division proceedings. In most jurisdictions in Australia, the evidence of a witness is given in 3 stages. The first stage is their evidence in chief. Evidence in chief is a witness's version of events. Secondly, under cross-examination. This is where the other side tests the witness's evidence through an in-depth questioning about their evidence in chief and any other relevant matters. Third, re-examination. This is an opportunity for the party calling the witness to ask him or her further questions, to clarify any issues that were unclear in the cross-examination. There are strict limits as to what to be covered with a witness in re-examination. It is not an opportunity to fix up what has gone wrong with your witness in cross-examination. Today, we are combining the topic to evidence in chief. In most civil jurisdictions in Australia, rather than asking questions, the evidence of a lay witness in chief is given by an affidavit. An affidavit is a statement made under oath which sets out a witness's version of events and attaches all of the documents relevant to the witness. It is essential to get a lay witness's evidence right. This can be time-consuming and at times frustrating, especially the case when it involves complex technical evidence regarding the operation and performance of machinery, as is the case in many manufacturing disputes. In Australia, there are rules which set out what a witness can give evidence of. These rules are applied differently in different jurisdictions throughout Australia. New South Wales is one of the stricter jurisdictions. The general rule is a lay witness can give evidence of things they saw, heard, touched, smelt, felt. They cannot give evidence about their conclusions about what happened, what someone told them happened, their opinion about what happened, or the contents of a document. It is crucial to get this document right. I can't emphasise this enough. It is worth investing the time and care needed to get this document completely accurate in every detail. An affidavit where the detail is incorrect, inconsistent, or which has avoided giving an explanation for difficult aspects of the evidence will quickly get a witness in trouble in the witness box and will be seized on by your opponent to attack the witness's credibility and the version of events put forward by your client. In my experience, European witnesses underestimate the rigours of cross-examination, and they do not appreciate the importance of telling the story accurately and in detail in their affidavit. This has to be insisted on when you are preparing the initial witness affidavits. It is very difficult, if not impossible, to try and compensate for an inadequate first affidavit later on. Trying to take an affidavit from a witness over the phone or by Skype in a couple of hours does not generally produce the best affidavit. For important witness, a face-to-face meeting where the witness is forced to set aside the time to give their full attention and the time needed to produce an affidavit is invaluable, even if that means travelling to see them. There are obviously proportionality considerations to be borne in mind. The size of the case, the amount of money involved are always factors to be considered in determining the lengths to be gone in preparing the evidence. But in any matter of a reasonable size, it is difficult to underestimate the value of a face-to-face meeting with the potential witness. It is so important to prepare your witnesses for the battle ahead. Until next time.